Thank you very much, Mike, for inviting us. We're going to try and stick to the salient points of mediation and hopefully focus it on the areas that are of interest to you as surveyors and finish off with just some examples. I've tweaked the examples today because I now know what the group that are here, and I wanted to make sure it's of interest to yourselves. So unfortunately, we have only one mic, so I'm going to have to do a little bit of swapping around with Amanda, so just bear with us and we'll try and make it quite quick. Right. We would just ask if you would just ask your questions at the end. If you haven't got time, I'm around this afternoon. Amanda's fortunately got to leave, but you can always contact us by telephone, and the details, no doubt, Mike has provided to you. Well, the reason for choosing mediation as a topic is I'm obviously a qualified mediator, civil and commercial, but I realised when I qualified, having gone through the course, that my original view on what mediation was about was incorrect. I thought it was all about finding a financial settlement, and that really isn't always the case, because a lot of the settlements that occur can occur afterwards, but it points out the strengths and weaknesses of the cases of the parties, and that is really so important because people become belligerent, particularly once costs are involved, which I'll go into more detail. So from my point of view, I thought mediation would be of interest because of the no-win, no-fee situation that we come across, which won't necessarily affect all of you, but the litigious nature of society today. There's an increased number of disputes. And also in England, there's a requirement to consider mediation under the court practice rules, of which I've detailed more on the slides. And if you don't, there can be cost penalties. So it's important that you consider it. In actual fact, the courts are setting up their own mediation side at the moment, and it's something which they're trying to encourage because the cost of litigation is amazingly expensive, and most people don't realise how much it does cost. But I imagine a lot of you have been involved in litigation. I don't know, how many people here have been involved in mediation? I don't know, put your hands up for some form of mediation. Oh, good, excellent. Right. So when is it needed and its uses, conflict and disputes? At some point in everybody's life, we come to a situation where there may be some form of conflict or dispute. I'm sure you've probably had it with your children as well. Mediation can be quite a useful thing to do with children. Not always successful, obviously, but still a good starting point. It can be during employment, and therefore there are people that specialise in employment issues. We don't deal with that, but we do deal with obviously civil and commercial and those that are related. The majority of people avoid conflict. We don't like conflict generally. There's very few of us that actually enjoy some form of conflict, but there are a few out there. One of the main reasons why people obviously avoid conflict is because it's time consuming and frequently protracted. I think if we've ever had a dispute or been involved in a dispute, what you think may be able to be resolved quite quickly frequently doesn't occur. It's a drain on financial resources. Sometimes it's a drain and you can't actually see the financial side being lost, but what normally happens is that the individuals involved, even the claimants as well as the defendants, find that they're drawn away from their businesses, and that is costing them money, although perhaps not obvious at first. It's usually very stressful. You can't get away from the stress of it because it's normally a financial stress combined with the worry of the outcome, and particularly if it's going to result in potentially a company folding, which I have seen before. There's uncertainty of outcome with litigation. You just don't know which way the judge is going to err. I've seen people go in very confidently, and I've been, particularly as a trainee, following around with somebody saying, yes, we're going to win this, and then suddenly you get a very, very strange decision by the judge, and then the decision is then, do you go further and appeal it? One of the purposes of using mediation, which is one of the alternative dispute resolutions that can be used, is to hopefully use it before the costs get out of control. And again, all of those that have been involved in mediations or claims of some type, you can imagine the costs that are involved with a lawyer at £280, £300, £400 an hour. It's very easy to find that an individual who's a claimant refuses to back down purely because those costs have got out of control. So it's important, if you're going to use alternative dispute resolution, to try and get it in at an early stage before people do become, as I said, belligerent and really don't want to change their mind on continuing on to court. So what is mediation? It's a non-binding, voluntary and without prejudice process in which a third party, known as a mediator, intervenes in a dispute as a facilitator of discussion with the intention of bringing the matter to a close in a settlement agreement. As I said, it's not necessarily a financial agreement. I've seen and heard of many other types of agreements. If the mediator is successful in assisting the conflicting parties to achieve a resolution, then a binding agreement is written. Now that agreement is done by the parties. It's not the mediator's role to draw that agreement up, although when I have been involved in one conflict, we had a Court of Appeal judge who did it part-time, and he actually drew it up for the parties because he was obviously capable of drawing the agreement up. But the mediator there is purely for facilitating to get the parties to basically speak to each other. At any time, either party may choose to terminate the mediation process and can continue the litigation process. That is very infrequently a result of commencement of mediation. Although you'll get people steamed up, generally what happens is that they will continue or go back into the rooms. But again, there is a possibility that they can just commence the process. And I think this last point is probably the most important, because at the end of the day, the mediator at least hopefully will help the individual identify what is salient and what is really the key issues for them. I remember one person who at the end of the day, it just happened to be popping outside, and though he'd been with his lawyer, and really all he wanted was an apology. And that's how it all started. It was as simple as that, and it was a point of principle. And that one settled with an apology and costs. So advantages of mediation: speed and cost. It's a relatively fast process. Generally, a dispute is dealt with in one day. Not always, but sometimes they can go over, but generally it's one day or less. Speed of resolution allows businesses or individuals, as I said, to return to normal life. And I think that's more important than anything, because people don't want to be involved in disputes. It just focuses them away from the other important parts of their business and their personal lives. Unlike litigation, mediation does bring the decision makers together. People often think of the lawyers as being the decision makers. They're not, it's the individuals. The number of times I've seen individuals, because they won't accept what their lawyer says, change their lawyers is quite frequent from what I've seen, particularly in pure commercial litigation. They find it quite easy to swap, particularly once the costs have gone up considerably. It avoids the usual court protocols and procedures in litigation, and hence those costs. And they can be substantial. So why is mediation often effective? It's not, as I've said there, it's not always effective, but it does try to break down some of the barriers that frequently prevent resolution of disputes. And those are really what one has in one's mind as about what one's going to get out of the case. And these, I think people get so entrenched in what they want to achieve that they actually probably miss a bit of reality at the end of the day. Parties not participating in mediation often maintain their positions as they feel they're right and reluctant to discuss issues with opponents. This stance frequently means that they leave their legal representatives to state their case with no flexibility for discussion or movement on any point, both sides become intransigent. The number of lawyers that I notice now, particularly because of the speed and requirements of today's society, still spend a lot of their time writing letters or emails. They still don't pick the phone up to talk to the other side. And the number of times I write and ask them to pick the phone up and talk to me, they're almost avoiding undertaking that process. And that is one of the things that just doesn't seem to have changed over the years that I've been working. In actual fact, I think now, in current society, it's probably getting worse. With intransigence, legal costs tend to rise, and commonly parties are then less willing to discuss or move on any point because they've expended so much money. And if they've got a high deductible or they've got a substantial amount of investment, then they're not going to wish to back down. And sometimes they won't even listen to their lawyers. And the other problem that you have is that when a lawyer works for a very large client and has done for years, sometimes they feel pressurised in following the course that the client wants and are not able to exert what they think is the correct advice that they've given, and to make sure that the client actually accepts it, often for fear of losing the business. So mediation can hopefully intervene and stop this occurring if undertaken early enough. So why is mediation... Have I just switched aside? Sorry, it's the last one there. Mediation is a private and confidential session providing an opportunity for parties to voice their views. It's sometimes allowing just this can be more important to a person than a financial settlement, which comes back to that case where I said it really came over the fact that somebody actually just wanted an apology. Right, a bit on the process. The mediator, as I said, is not there to provide advice to anybody. They're there to just facilitate discussions. And that's something really that lawyers should be doing without this process. But there's been a necessity to use alternative dispute resolutions, including mediation. So the mediator initially has both parties together and allows them to summarise their case in front of each other. He or she then has private and confidential sessions with each party, and then he or she provides the clear means or method of communication between each party, with the permission of each party attending. At each time, you have to get the authority to pass any information between parties. You're not there just to say, oh, he says this, he says that. You have to get clear authority from each party. The entire process is confidential, though Amanda will expand on that. This process allows commercially sensitive information to be discussed without, in theory, the other party using the volunteered information in litigation later on. Parties who mediate do so at their own free will, well, subject to obviously requirements of the court now, but you know, they do have to go their own free will. This encourages certain settlements that a court could not order, such as discounts on future transactions. And I think that's really important because sometimes that can often lead to continuations of business relationships as opposed to loss of them, which litigation tends to result in. So, right, more on the process, and I'm over to Amanda to go through which I think is probably some more of the interesting side of mediation. So, thank you.
Thank you, Karen. More on the process. So I'm going to sort of more or less read these through, actually. Because mediation can be illuminating for parties, as often at the start of the process, they may have an inflated sense of confidence in their claim. And the mediator's role, as Karen's already touched on, is to try to make each party see the other's case and strengths and weaknesses thereof. And I've missed out one. There we are. And then the mediation process provides an opportunity for each party to assess whether their case is as strong as they first thought, and encourages them to think about the litigious risks and their real desires. In other words, exactly what it is they are hoping to achieve from the process. Sometimes it can save a business relationship or even a personal friendship that may otherwise have been at best compromised or maybe even lost. So I hear you ask, are there any disadvantages? Well, cost, time, opponents knowing the real strength of your case, release of knowledge for commercial advantage, and parties possibly misleading others are all disadvantages. Well, it could be argued that they are all disadvantages, but this is not always the case, as we shall see. Cost is, as we've already seen, often an advantage, as whilst an unsuccessful mediation can be an added layer of costs, the overall cost of litigation can be reduced as issues have often been narrowed, thereby saving costs as these issues are less likely to be raised again during any litigation. Time, perhaps? Well, not necessarily. Mediation generally lasts a day, which, if the mediation is unsuccessful, could be perceived as a waste of time. But if it has narrowed the issues, it is more likely that time will actually have been saved. Knowledge and commercial advantage. Well, as far as this is concerned, mediation is confidential, but whilst discussions are not admissible in terms of evidence, disclosure of information might still be used for commercial advantage in future trade or to assist lawyers in narrowing cross-examination should confidentiality be broken. If the issues are commercially sensitive, I suppose this may be the thing that might put people off mediation. And then we get to parties misleading others. The parties are not under oath as they would be in court, so a party could mislead the other about the strengths of their case and the evidence. But a skillful mediator would be able to question the validity of something that doesn't seem to match the facts, whilst remaining impartial, which, as we know, is very important. And on a final point here, a mediator will try to ensure the parties are on an equal footing, even if a wealthy party has engaged expensive lawyers or counsel. So then, why is mediation generally effective? Well, mediation works because it is a confidential process that allows parties to communicate. And as Karen said as well, they're more likely to talk. So they would be communicating face to face, not via email or through lawyers at this point. Generally, they attend to settle a dispute with the expectation of making some concession. They can tell each other their case without necessarily going through lawyers. And they can explore mutual concessions to reach settlement. The other thing they can do is vent. Now, this is a word that we rather like, venting, as we all do it from time to time, particularly to partners, children, anyone really. Anyway, venting is often more important to people than money or winning, which again Karen has already mentioned. And it's usually about the principle and getting their point across. Because mediation is not a court of law, it does not have the rigid procedural rules for each party to comply with, although the mediator, of course, must comply with the rules of mediation, as they must not provide opinion or take sides, just to reiterate that, because that's important. Oh, sliding off.
Sliding off my glass case.
It's sliding off your glasses case. Right, sorry for that little interruption there. So the mediator does not act as a judge or as an arbitrator. They're an independent person whose job it is to facilitate discussion through which a dispute can hopefully be resolved. Although it is sadly common for a dispute to have been going on for months or even years before mediation occurs, often badly affecting all parties involved in some way or another. Attending is a positive step towards progressing a resolution under the skillful guidance of a mediator. And perhaps, we like to think, will occasionally result in personal and business relationships not being damaged. Body language. You like this one. Body language, speech, and the ability to listen. Well, these are all everyday skills that we all use. And I know we've all heard ad infinitum about judging a person on first impressions or a book by its cover, if you prefer. But body language and speech are hugely important when meeting someone for the first time, especially on the day of mediation, which might be the only time everyone meets. So it's imperative for the mediator especially to win the confidence of the parties from the outset. Body language can achieve this before anyone has even spoken. So it should therefore follow that the language of speech can reinforce positive body language. Thus, the mediator's role is largely about observing the posture of the parties, listening to what they have to say, and interpreting all of this throughout the process, thereby helping to guide the mediation to a successful conclusion. So we'll begin with body language. No crossing of arms, pointing of fingers, or pulling faces, which should really be obvious. Listening. Now, this is probably more important to the mediator's role, but it does help if the parties listen without interrupting each other, as it allows them to explain their reason for the complaint and hence the cause of the dispute in their view. Venting. There we go. Venting, very cathartic again. Let the other party vent their emotions and then allow them to calm down. It is the same in all relationships. If you let somebody talk, they tend to see things more clearly and may even reconsider their options, or quite possibly even acquiesce on a few points. Think before you speak. Now that's something we're taught from a very young age, but in the heat of the moment, it's a lesson easily forgotten. Think about what you want to say, and more importantly, what you want to get across. Think about how the other party will perceive and understand your point. So think carefully about the construction of your sentences and phrases before saying anything so as not to be misunderstood. And finally, speech. Speak calmly, but in an authoritative manner, using both open and closed questions. I think that's done.
We thought now, I've got one example which you may find of interest on a commercial point.
You might need this.
And you can hear it. So,
Yeah, we're going to mic her up again, Mike.
I've got a couple of examples, one in particular that you'll probably find of interest, something which happened many years ago. I'll just plug myself on. That's just to summarise the role of the mediator. It's to be independent, unbiased third party who facilitates, which is something which obviously we've hopefully expressed through the whole of this talk. But one of the more interesting cases, which I think is probably relevant because of today's topics, occurred probably it must have been about 12 years ago. It was actually with the Killary Flyer. You can read the judgment if you wish. I can't remember, I think it was actually in Scotland in total. But the interesting thing with that claim started off somewhere in the region, if I remember, £30,000. And this is a typical example of when things get out of control. Now, in those days, insurers were quite belligerent and I think didn't want to settle. It may be a combination, I can't remember, with the insured or the insurer didn't want to settle. And it started off with a vessel that was aluminium, which had a problem with, if I recall, the filling of it. And I think it had 3 different types of primer or whatever it was on it. I can't remember the exact detail, but it was very interesting because then they decided they'd obviously rubbed it down, the building yard that was supposed to be specialist, and then painted over the top. Well, this went on for quite a few years, and I was involved in, when I had first qualified, reviewing this case for the underwriters. And by this time, though, it had gone too far and they were well into litigation. And what happened in the end, this thing settled for $140,000. And there'd been no mediation done. Again, you can read the case, all the judgments out there. But on top of that, if I recall, the same figure was required, if not more, for the lawyer's fees. And this is sort of an example of something getting out of control. In those days, people didn't really think much about alternative dispute resolution. It's more the last decade, particularly with the courts now forcing things through. But that's a really good example of what, to me, is a complete waste of money. And at the end of the day, the reason why I feel quite strongly about it, because perhaps the few of us here that have pensions, etc., we are shareholders technically, because most of these funds actually go into insurance companies. And that's where they actually invest. So, you know, that's a nice sort of $250,000 or whatever off of, you know, percentage off of our funds, because our pensions invest heavily, because the insurance industry, as probably most of you know, is probably one of the largest invisible earnings for this country. So every time that sort of thing happens, it takes something off our bottom line in total in our economy. So that's one of the reasons. That's from a commercial perspective. But from the other point of view, it didn't do anybody any good, because all the stress, etc., that occurred as a result of it, and the time that's taken away, and the time in court, and forming witness statements take ages to produce correctly in time. It really must have affected the business. I don't know to what degree, but it took the person who was in control and others away from what they were involved in. So I think that's probably a very good example. And again, if you wish to read the judgment, it's a very interesting judgment about coatings on the aluminium vessel, and the liabilities that arose from it. And that was probably my first main introduction into what is probably coatings, etc., and my involvement in it. But do you ever get a chance, do read the case. You'll find it very interesting. Thank you.
Karen, thank you, and Amanda, thank you very much.
Okay.